Call this meeting of the Town of Clayton Board of Adjustment to order. Our first agenda item tonight is any adjustments to the agenda. I don't know of any adjustments. Staff, Ben, any adjustments to the agenda? Okay, no adjustments. Item 3, approval of the minutes of the February 16th, 2022 Board of Adjustment meeting. Anyone have any corrections or comments?
Move to approve.
Second.
I'll ask, thanks for those motions. I did notice one thing, staff, council member Andrea Archer, board liaison. Was that correct? Yeah, so I think we need to substitute Andrea for, substitute Avery for Andrea, so. Any other discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. All right, seeing we have no public hearings tonight, we'll move to old business, item 5A, findings and conclusion of case 2021-113 variance Buckskin Garage, an item that we heard at our last meeting. And we have those findings in front of us. Assume everyone's had time to review those. Any comments by our board attorney or staff? Any discussion from the board? Any corrections, comments? Okay, with that, I will entertain a motion.
Move to approve the findings and conclusion for the 2021-113 VAR Buckskin Garage.
Have a motion and have a second. You have a motion by Mr. Perricone, second by Mr. Satterfield. All those in favor say aye. Aye. Opposed? Motion carries. Item 5B, findings and conclusions for case 2021-152 variance Med Spring Drive Shell. Also another case that we heard at our last meeting. Any comments or anything from staff? Nothing? Any discussion by the board?
Chairman, I'll just make one comment. The findings and conclusions, if you had multiple parties to draw up findings and conclusions, they'd all come up with different findings and conclusions. The idea is to provide enough findings of fact to set the stage and to give the background to the request for the variance, and then to set out those findings and conclusions that lead you to the 4 statutory determinations of hardship, not self-inflicted, and so forth. So this, and the standard on review, if there's an appeal, the standard on review is not whether the findings and conclusions perfectly lead to the decision. It's whether there is substantial, competent, and material evidence in the record. So it's all that evidence that's the backdrop and is the appeal determinant, not whether the findings and conclusions tie everything together just the way the court might like to see them tied together. So that just, these are not intended to be the one and only or the perfect findings and conclusions, but we've just tried to draft findings, conclusions, and a decision that reasonably provides notice of what's going on and ties the facts, the evidence with the facts, with the conclusions and the decision. That's my summary of the process.
Okay. Thank you, Raz. All right, do we have a motion to approve?
A motion to approve the findings of facts and law.
We have a motion, do we have a second?
I'll second.
Okay, we have a motion by Mr. Antons, a second by Ms. Berry. All those in favor say aye. Aye. Opposed? Motion carries. Item 6, training. 6A, town attorney will provide training. We'll turn it over to Mr. Raspberry.
Thank you, Mr. Chairman. I'm happy to offer 10 to 15 minutes of training. That's generally what y'all are interested in seeing and hearing. I have condensed and updated copies of the outline of the presentation that I made to the board about a year ago as the board was being constituted. And I'll hand those out, particularly for them, for the folks who do go through that. But I do not intend to plow all that whole ground the second time. I'll just at the high school response and then answer questions.
Sounds good.
Appreciate it.
Thank you.
Let me just begin with, I'm so sorry, I keep forgetting this. Keep the button down requirement now. The Board of Adjustment, as it hears its cases, conducts what are now supposed to be called under the statutes evidentiary hearing. The point of that is to put particular emphasis on the fact that this is not just your average public hearing as the City Council would conduct on rezonings, budgetary issues, questions of adopting or not adopting an ordinance. These are more court-like in nature. These are mini trials, if you will. And the essence of the process is that the board, in each of its cases, will hear evidence being presented, which ideally will be more focused to the issues before you, and will not be just everybody has a chance to have his say, which is the philosophy behind public hearings, if you will. So the process is quasi-judicial. Lawyers abbreviate it as QJ. Quasi-judicial is a mouthful. And on the first page of the summary, we try to outline the distinctions between the legislative processes of government, including legislative hearings, the conventional public hearing, administrative activities of city governments, which are non-discretionary, it's just routine box checking. Usually that's done by the staff. And the quasi-judicial process, which you all are involved with as you hear either requests for interpretation appeals on administrative decisions, if a zoning administrator or inspections administrator, or anyone who administers the development regulations of the town makes a decision and a property owner or other party has issues with that, there is an avenue for appeal, and you are the board that hear those administrative appeals. That's one type of case you hear. Far and away, the more frequent type of case will be the variance request, which is a request to waive or vary the strict literal enforcement of a particular provision of the town's development regulations because the owner contends that they are under a special unnecessary hardship. The basic legal principles pertaining to QJ proceedings are straight from the United States Constitution. There are 9 rights that the parties that appear before you have in a QJ proceeding. I won't go through them all, but the right to cross-examine witnesses, have an attorney, many of the same rights that you will see evidenced in a court proceeding. I've mentioned the 2 functions of the BOA, to hear variance applications and appeals of administrative determinations regarding the zoning and other development regulations of the city. It's not just zoning. It could be soil erosion, sedimentation, other development regulations of the city, building code enforcement, that sort of thing, not just zoning. Zoning, I think, is more typically the subject area for these requests for variances that you all will hear and rule on. Page 3, we've got the order of the hearings. I think it's pretty straightforward, and it's something that you would inspect. It's intuitive, if you will. You generally hear the applicant first. The applicant is sworn in. All witnesses have to be sworn in. That's required by due process, and the applicant will present its case, including the applicant's testimony or any other witnesses that are speaking for the proponent, the applicant, for, let's just say, a variance. This is followed by questions from the board of each witness that is appearing as the applicant's case is being presented. At the conclusion of the applicant's evidence, then the chair will call for any others to speak in opposition, any others to speak in favor of the application, go through the same process. They present testimony, subject themselves to questions from the board members. Following that, the chair will ask for, if anyone chooses to speak or desires to speak in opposition to the request. So you go through that process with the opponent's evidence. The applicant has an opportunity for rebuttal, and typically my experience is that if anyone has something to add, there's discretion to go back and forth if there's a particular issue, and you sense there may be helpful information that would be forthcoming if a party would have an opportunity to go back to the podium and testify further, further evidence. One of the challenges of these types of proceedings is that, unlike in a court of law, there are no statewide rules of procedure. You all have adopted very general rules of procedure, but in the courts of law, there are pages and pages and pages of procedural rules, and particularly rules concerning receiving evidence. And there are no statewide rules governing local government, controlling local government quasi-judicial hearings. And it makes it tough because we've been to some communities where the process is very formalized, rather rigid. The chair and the board take a fairly firm stance on the procedure, if you will. They analogize to the rules applicable in courts quite often. Other times it's just almost like just a family conversation. And that varies further depending upon whether a case is contested and a high stakes case, and whether lawyers are involved. Some of your cases are just as folksy as can be and seem utterly routine, just like a committee decision. And other cases, everyone squares off and gets their hackles up, and the lawyers sort of elevate the tone, and it becomes a tense, formalistic affair. And the challenge is, and I can't say enough about how knowledgeable and experienced and effective your chair is, but it's really challenging for lay folks in an unfamiliar setting like this to set just that right tone where you can make an adjustment toward formality in the tough cases and the contested cases, but at the same time keep the process businesslike and formal enough in the less controversial cases that just seem to breeze right through. But that's the challenge, finding the right level of formality. Next item is burden of producing evidence. And I told Ben earlier this evening that his timing was perfect because that's one of the points I think that deserves particular emphasis in discussing pitfalls and challenges to a local Board of Adjustment. And I'll just use the variance situation as an example because that will be the most frequent item of business that you are involved with. But in, for example, a variance case, the applicant has the burden of producing substantial, competent material evidence in order to make the showings that are required by statute. I think we've done the variance cases before, and you all will recall that the staff report will include 4 specific findings or determinations that are the issues in a variance case. And I won't go through it word by word, but basically the applicant has the burden of showing why it would put the applicant under unnecessary hardship to have to comply with the literal requirements of the city's development regulations. The second finding is that the hardship is not self-inflicted. That is, the applicant did not create the hardship, which he or she is now, or it is now trying to get around. And some more generalized findings that the granting of the variance is in keeping with the overall intent of the town's development regulations, in this case zoning ordinance, and also that the public health, safety, welfare will not be prejudiced or impaired if the variance is granted. These are the statutory criteria, and the framework of these evidentiary hearings on variance applications is that the applicant must show by substantial competent material evidence that those legal standards have been satisfied. So it's evidence, facts, and these 4 conclusions that have to be reached in order to support your decision to approve or deny. There's been recent litigation and recent appellate decisions on this topic of what burden the applicant carries. We used to say that the applicant has the burden of proof or persuasion. 2 recent decisions of our Supreme Court hold that this is not the case. That's not so. The applicant has the burden only of producing substantial competent material evidence that tends to show that the 4 conditions for granting a variance have been satisfied. The standard as handed down by these appellate decisions now is, I would say, fairly minimal, and that's particularly so if there is no opposition evidence. And as you all are aware, it's not unusual when something's not particularly controversial that neighbors and others don't bother to come out, no parties bother to appear at the hearing and to introduce opposition evidence. These court decisions have held that if the applicant produces, and I love this term because lawyers love these words, only a scintilla of evidence that to support that the standards have been met, that satisfies the applicant's burden of production of evidence, and the burden shifts to opponents, to those opposed to the proposal, the application for variance. And if it's a default, if there is no evidence that appears to counter the scintilla of evidence that the applicant has presented to show that he's met his burden of, and I'll use the masculine singular, but if he has satisfied this burden of production, not of persuasion, the board has very little or no discretion to deny the applicant. And I hope I'm not giving you too much information about this, but it to me is just a really crucial decision, and to some extent, it takes away the board's authority to use its judgment and knowledge and discretion. There has to be evidence that comes to you. You're not allowed to just critically evaluate what you hear from the applicant and decide that that's not credible, that's not persuasive at all, I don't believe it. If there's no opposition evidence, you are bound to believe it and to take it as persuasive and leading to the decision to grant the variance. It's good to have a chance to discuss this with you because you don't want to go on record at a hearing. The attorney certainly doesn't want to articulate what would be an applicant's evidence on appeal should a variance application be denied, because you just didn't buy what you were hearing. But if there's no evidence, your hands are more or less tied. And that's exactly what happened in the Asheville case. It was a special use permit determination by the council of the city of Asheville. This was the PHG decision that was referenced in the School of Government blog post that Ben sent to you. In that case, it was a high-rise parking deck and office building in downtown Asheville. And one of the criteria for the special use permit, just analogous to the criteria on deciding whether variance is deserving or not, the criteria was that there would be no significant increase in traffic and there would be no loss of property value with respect to adjacent properties. And the applicant put on an expert witness on property value and appraisal and an expert traffic control, traffic management witness. And one of the members of the city council making the decision was a licensed real estate broker. And everyone on that board had familiarity with traffic in downtown Asheville, and they asked fairly hostile questions of these two expert witnesses, saying, you didn't do this in your appraisal, this appraisal ignored these factors, you didn't do your testing during peak traffic hours. We know how bad the traffic gets outside of this particular block in downtown Asheville. They were very, very skeptical, and they chose not to be persuaded by these two experts. Well, there were no parties speaking in opposition to the application for the special use permit. Went to the Court of Appeals, and the Court of Appeals said, nope, you could not just simply choose to disbelieve or be skeptical of what you heard, since there was no evidence to rebut that. You had to accept it as persuasive, and it dictated your decision in that case. Yes, sir.
Do I need to be on mic for this? Are we still taping? If someone from the opposition had stepped up and hired someone else to do an appraisal and a traffic study, and they presented contrary information in that case, could that have been considered, because now it's coming from an expert witness?
If there is opposition evidence, the burden of persuasion then falls to the Board of Adjustment. You then can critically weigh and evaluate what you've heard on not just one side, but both sides. And in that case, it's interesting because it's a dramatic switch in your role and the right you have to exercise discretion and have the court respect that exercise of discretion. You then, the board then, is in a position to evaluate whether the applicant's testimony was more believable or persuasive, whether the opponent's evidence was more believable and persuasive. And the board is charged with finding where did you find the most substantial or the most convincing substantial material evidence. I mean, the court is supposed to defer to that. The court can't substitute its judgment in review for the
hearing, before the hearing tribunal. So if you're hearing evidence from both sides, you have lots of discretion to evaluate what you've heard and make a decision based on that. But if there's no evidence only comes from the applicant's side, in those cases, you are probably down. And I think that's kind of upset a little bit, because to say that you come here as volunteers, knowledgeable and experienced, and the whole requirement for the evidentiary hearing is because some judgment has to be exercised. If you don't hear evidence construct, you can exercise your judgment.
Now, did you say that there was a board member that was a real estate appraiser?
Yes, sir.
You did?
Yes, well, that was.
And his opinion would not matter? Could he step down and be in opposition?
No, because you can't be a witness. I mean, first of all, the only thing that the board is supposed to consider in terms of testimony is sworn testimony. Now, you all are decision makers, and the applicant has the due process right to a fair and impartial tribunal. And frankly, I think if a decision maker, if the judge that was here in the case, in the middle of the case said, I'm going to step down, I'm going to go here and be a witness, and I'm going to ask another judge to come in and be decided here, I think that would be procedurally fatal. I don't think that would pass muster. You sort of have to put on what judges have, as you sit here. Even though you may think that kind of a day, I sit with the Raleigh Historic Preservation Commission, everybody there is a preservationist or an architect, and they're devoted to the cause, and they consider themselves to be protectors of the historic fabric of Raleigh. Explaining to them that nope, all the knowledge you bring to this table is not the same as sworn evidence. It doesn't count. It helps you understand the evidence, but you can't say, in deciding the case, you can't say, I'm a better architect than their architect. And I know that what our testimony is worthless. If there's not a witness that refutes the testimony as a decision maker, you're not allowed to just apply your usual expertise.
I'm so sorry. You can't apply your own expertise and knowledge to guide the decision. So the lesson is beware if there is no opposition evidence. If you are inclined to feel that an application should be denied, be very careful in those circumstances.
Can I ask a question as well? At the beginning of your training, you did state that there's rarely opposition to the people who are bringing these requests to the board. And my question is, what is the burden of the town to inform interested parties? You know, I think we all remember the day when the newspaper came out and you saw the petitions that were being brought to the town. And now I think we've become so disparate. I wonder if we're doing our due diligence in informing interested parties in cases that may be of interest to them. And what is the burden of the town to make sure that the right people are informed, that they aren't surprised whenever action is taken?
That's a tricky question to answer. The legal burden in terms of the notice that has to be posted is straight out of the statutes, and you have to give notice to adjacent property owners. I think Raleigh has a distance standard. I'm not sure exactly what it is, but it's 100 feet on either side. But there is absolutely no legal requirement that the town give more notice or provide more of the backstory on these applications and how important it may be if others are interested in a case being heard to appear and offer testimony. when all this was coming down with Raleigh's historic crowd, the historic commission people said, do we hire our own witness? Do we need to get the word out? Do we need to have a division in city government to go spread the word and to be an advocate in opposition to some cases that might be bad cases? Who knows? All I can say as your counsel is that when you are sitting here and hearing cases, it is absolutely legally required that you be fair and impartial and don't bring an agenda or even views on development issues.
I would like to go on record that I am fair and impartial. I mean, that is not at all what I'm implying. But at the beginning of that training, you stated that there is rarely opposition, and that's what causes pause and concern. That if the town, we have certainly moved to more disparate means of communication, and I hope that the town is doing their due diligence in ensuring that people are informed that are interested in the case that may affect them. I think that's the right thing to do as stewards of the community, and making sure that all voices are heard.
Absolutely. I mean, it's local government. That's what local government should be all about. And I certainly didn't mean to suggest it. No, I would confess to bringing views on development issues to the work here, but the fact is, your views, whatever views you may have, can't take the place of evidence. And if there's not evidence coming in, I hate to say your hands are tied, but in certainly many circumstances, your hands will be tied to find in favor. And which is exactly what that blog post says, that if the applicant meets the burden of showing by prima facie evidence, substantial competent material evidence that he or she deserves a variance, and only by just a minimal amount of evidence does he have to show that, then without evidence contra, your hands are pretty much tied. Yes, sir.
So two things that probably should just think about is oftentimes applicants will provide conflicting evidence. And if there's no opposition, then how to weigh the conflicting evidence that the applicant themselves may bring forward. And then the other part of that too is sometimes they may provide evidence that has nothing to do with the portion of the UDO that they're trying to get a variance for. So those are two issues that the applicant, even if uncontested, we have to consider. The appropriateness of the variance, generally speaking, if they even have evidence that supports what they're trying to get a variance for, and then if they actually conflict themselves.
You're looking for wiggle room in the face of these legal principles that have just been handed down. That's, in my view, where the wiggle room is. That ties in beautifully with at the bottom of the page. Nobody else remembers Perry Mason. I do. I lived through Perry Mason. But substantial competent material evidence. Substantial, those are not just lawyer words. Substantial means the quantity of evidence, that it's enough and that it's sufficient. Competent means trustworthy, reliable, valid. You've not got an issue that requires special expertise and somebody's talking through their hat without any competence to do that. Material means relevant and having probative value. A classic example of irrelevant evidence is if an applicant just says he or she is a good guy and they've gone through financial hardship, or therefore they are deserving. The criteria for showing hardship should relate to the property itself, topography, setbacks, the existence of easements that impair development flexibility, as you heard last month, that kind of thing. So if there is room to be unconvinced, or to feel that the applicant just simply hasn't met their burden, that's probably where the room is, that they might have had an effective presentation, but they really didn't talk about hardship. They really didn't introduce evidence that keyed in on hardship or some of these other statutory criteria. That's where if there was an appeal and the town were defending the appeal, if it was a denial, and we were the case was being defended, that's an area where attorneys for the town would look to defend the decision to deny. That the evidence wasn't on point enough or clear enough, relevant enough to rise to that level of being competent, substantial, and material. So they didn't meet the burden. You didn't need opposition evidence if they didn't meet the burden. It's just these two cases we've looked at, the PHG case in Asheville and the Fayetteville case. The courts didn't require a great deal of strong, persuasive, competent material evidence, just a minimum amount, as long as it's sort of on target, may be enough. But like I say, those are the issues. Don't have all questions answered, of course, but those are the issues.
Question related to that. Expert testimony and evidence. Can evidence only be presented by someone, quote, deemed to be an expert? Or can you provide evidence, can anyone provide evidence as long as it's substantiated?
To answer your question, the law is that local QJ boards are not bound generally by the strict rules of evidence, with 3 specific statutory exceptions. The first is any evidence that goes to the issue of property value, and typically it's diminution in property value is the issue, must be supported by expert testimony, real estate experts, land appraisers, others having expert credentials, special knowledge and experience that allows them to testify on those topics. The second statutory exception where the strict rules apply is traffic safety. If there's an issue of traffic safety, and I think also traffic congestion, I'll check the statute, but generally traffic testimony concerning traffic impacts of a variance request or a proposed special use permit, that has to be in the form of expert testimony, someone who's a traffic consultant, special credentials in that field. And the third exception is, let me back up. It used to be that if there were no objections raised by any party to the hearing, and if the evidence appeared to have some relevance and usefulness, strict rules didn't apply. It was okay for the board to hear it, and it was okay for the board to consider it. The rule now is, even if there's no objection to the evidence, experts have to appear and testify in order for the board to receive evidence on property value, traffic safety, and congestion. And the third, much larger exception is any other area of opinion testimony, not testimony as to facts, but expressing an opinion that requires special knowledge, experience, or expertise, that must be provided by someone who would be an admissible expert, a qualified expert witness in a court of law. So anytime you get into you get a soil scientist or a structural engineer or horticulturalist, any of those areas, if someone's talking about getting down into specialized areas regarding any of those fields of study and endeavor, if they're presenting opinion testimony, probably they need for that testimony to be pre-qualified as expert testimony. And it's tricky. There's no, some judges in courts of law are very loose in applying that standard. They'll let anyone that has some qualifications testify. In some ways, I've heard the opinion expressed that, gosh, Board of Adjustments have got to be more uptight about that issue than judges do, because judges just sort of sometimes do their own thing. There's just generally a sense that citizens of Clayton deserve an opportunity to go to the microphone and speak if they are interested in that. It's only when they get woefully repetitive or they just are completely off topic, that's when it's, in my experience, the chairperson is tempted to rein in that particular witness. But no, not strict rules of evidence except those three exceptions. And a good example of that is documents are all hearsay. It's quite common for local boards to accept documents, even if the author is not present. And typically when that, just because it's rather burdensome in this setting to require everybody to have witnesses troop down and testify as to everything as opposed to a sealed engineer's document or a set of plans or something of that sort. What I've suggested is that excess evidence, or excuse me, evidence that would not pass muster in a court of law because it's hearsay, because the creator of the document, for example, or is not present to be cross-examined, as long as it is not pivotal to the decision, it's not a problem. Surplus evidence is not a problem. Evidence that's not very good evidence that is critical and pivotal to the decision is where you get into difficulties. So you could have a non-expert giving an opinion about something that really wasn't terribly important to help you make a decision. Don't be quite too upset about that, but if the entire decision depends on what that non-qualified individual was opining, that's when you've got a decision that might be challengeable. And that's, let's see, findings and conclusions. As it has turned out, our office has taken on the task of preparing findings and conclusions in your cases. They are, like I say, not the perfect findings and conclusions. They're just an attempt to set the stage and to connect the evidence that's important with the conclusions that are important to the decision that is determinative. And the basis of a review is not whether it's the perfect order, but whether generally in the record there is evidence that can lead the court to sustain a decision that the Board of Adjustment made in a case. Decision options. I think this is old hat to most of you, but in the case of variances, your decision could be either to grant the variance application, to approve the variance application, or to approve with conditions, or to deny. So it's grant or approve is one, obviously. Approve with conditions or to deny. So there are three options on variance cases in terms of action that you may take. Appeals of administrative decisions. I think you've had one of those in recent months, and generally speaking, the decision options you have available to you are to either affirm the decision of the zoning administrator or an inspections officer, or to reverse that decision. And the decisions that you make run with the land. That means these are entitlements that stay with the land even if ownership of that property changes hands. So if a variance is granted to not strictly comply with a setback requirement, for example, a successor in title can avail themselves of that variance. It runs with the land. And I think that covers just about all the topics I wanted to mention. One point I thought I might discuss real briefly is the North Carolina State Bar Rule, providing that local quasi-judicial proceedings are enough like court proceedings that parties other than individuals bringing their own cases before you and testifying on their own behalf, with that one exception, parties before you need to be represented by counsel. And that arises when you have corporate property owner applicants, where you have LLC property owner applicants. And it also may appear if you have a witness who is sort of carrying the burden of presenting the case, and the witness explains that they are John Smith with McDivitt and Street Engineering, for example, because they can't represent their company. And one strategy for avoiding a problem there is for your counsel. I have done this, I think last month I did this, just to ask if the witness will acknowledge for the record that they are appearing only as a fact witness and they're not there to summarize the case, to make arguments regarding hardship or any of the other legal issues, or to otherwise do what lawyers would do in a representative, in the capacity of representing some other party or entity. So that's the reason for that somewhat annoying interruption that I have made in the past to talk to folks who are representing someone or hold themselves out as representing someone. And that's about it. Anyone can speak at your hearings, but there's a body of law concerning standing. Only certain individuals, the property owner, a contract purchaser, a lessee, can be an applicant before you. And those who are opposed have standing only if they can show special circumstances that justify their having due process rights, and that includes the right to appeal a case. So practically anyone who has something relevant to say can testify, but only those parties with standing under the general statutes in the case have the legal right to be protected by due process guarantees. That is, they could ask questions and cross-examine witnesses only if they have standing, or to appeal, or to appear as a party in an appeal of your decision. So that term may come up whether a party has standing or not, and I can, if the issue arises, I obviously can try to help sort through that if it's important in the case. But otherwise, the general thinking is that most folks who have something of some relevance to say will be allowed to testify, even though technically they wouldn't in a court of law, and technically they may not have a lot that's particularly important or helpful in the case, and that's just trying to allow citizens to speak. Just the way government works at this level. And that's all I have. If there are any further questions, obviously, as questions come up as the cases progress, or if any of y'all want to send me an email or give me a call, happy to to chat if you desire that about this work.
Thank you, Raz. Any other questions for Raz?
I want to say this was very helpful. Thank you very much for providing this information.
This is not easy. I marvel being volunteers at asking 5 or 6 lay folks to put on judges' hats and jurors' garb and thread through the legal, challenges. It's a very tall order. I'm amazed that I'm amazed there's not more frustration than is expressed, because I can see it would be very frustrating having to meet these standards the courts have put on. The whole idea was to try to make the process, and frankly, to make the process more difficult to the home builders and the general contractors lobbied most of these recent statutory changes into our general statutes with the thought that it would make it more difficult to regulate or restrict private property rights. Honestly, that's my thought, but most folks who've looked at the process would probably acknowledge that. But the end result has been that the process is a whole lot more finicky than it used to be, a whole lot more formalized, a lot more lawyering is involved in it.
Whereas you sparked the question, not to make it run too long, but I was involved in a case once where the witness was questioned. It was questionable whether or not he was considered an expert witness or not. Is the board, or are we as a board, tasked with determining whether or not, based on the credentials provided, whether or not that witness is an expert witness or not?
That's the way it works in a court of law. Before an expert witness can express his or her opinion, they are qualified. And the lawyer that's offering the witness asks the witness questions. They go through their biography and experience and their professional education and so forth. And then opposing counsel has an opportunity to cross-examine on those points. generally speaking, if you've got the degree, you've got some job experience, you'll be allowed to address. Part of the cross-examination is just to test out at the front end. If the witness says what the witness is going to say, in order to create a questioning and perhaps skeptical perspective by those who really exist. Yeah, that normally comes in. Normally comes in. You got the degree, you got the job, you can be allowed to work law, and I think as chair, you probably, I'd be much best to imagine a scenario where someone is before you, that you say,
Yeah, I was a little surprised, yeah. And in this case, I'm talking about as an example, it was, a special use permit and defining about property values, will this devalue property values? And the witness was not an appraiser, licensed appraiser in the state of North Carolina. He was a realtor, broker with probably 35 to 40 years of experience. And there was some discussion. I could understand that. The board finally decided that they considered him an expert. So a little discussion there had to happen, but.
And that's not surprising. I was eminent domain condemnation lawyer for many, many, many years, and we always used real estate appraisers and sort of had a sense that certain real estate brokers were not, they hadn't gone through the training, they weren't as qualified as licensed appraisers. But the courts allow them. That's one of those areas where you're considered to be an expert if you've got a brokerage license with some experience, even though land valuation is not really your targeted field.
Okay, well, thank you. Any other questions for Raz? All right, thank you, Raz. We appreciate that. Okay, we have any new business? I see none. Last item is adjournment. Entertain a motion to adjourn.
Motion adjourned.
Motion by Mr. Satterfield. Do we have a second?
Second.
We have a second. All in favor, say aye.
Aye.
Motion carries. Good evening.